What's up, good people of YouTube or Eternia or whatever universe, time, and relative displacement in space that we are? Let's get going. Once again, guys, if this is your first time here, make sure you hit that bell and subscribe, and please watch the other videos. You're just seeing this one. There's a whole set. All right. Should be like five, four, or five, maybe even six of these. I will have the link to this video and the one preceding it. They'll pop up so that way you can catch the first one and then go right down through all of them. All right. With that being said, no big bells and whistles on this one. Let's just jump in and let my lovely assistant guide thee. Now, to give some context, I guess, before we jump into it, this particular video is about right to travel and all the various things that come along with doing right to travel the correct way. As or the AI reads through, next section is going to be talking about taxation, how they're taxing us and why they either can or cannot, depending on if we're public or private, do what they're doing in exercising a protected right. If you're doing something on the public side as a public U.S. citizen, then they have the right, the legal right to do what they're doing. If you're operating correctly and privately, they do not have it. And they are infringing it as a lawsuit. Let's get back to it. All right.
Taxation. The exertion of power used in the case of private travel cannot, however, be the power of taxation, since an attempt to levy a tax upon a right would be open to constitutional objection. A state may not levy a tax or fee on the exercise of a protected right. A right that may be taxed is not a right but a mere privilege. Each law relating to the use of police power must ask three questions. 1. Is there threatened danger? 2. Does a regulation involve a constitutional right? 3. Is this regulation reasonable? People v. Smith 108 AM. St. Republic 715. To the first, as discussed earlier herein, the term threatened danger requires the state to show a compelling interest. That compelling interest has been considered by the courts, and they have determined that businesses whom spend, in all probability, the better part of a business day on the highways are more of a threat than those who infrequently occasion the roads for quick trips to a market. The automobile is not inherently dangerous. Cohen and others v. Metter 119 VA 429, 89 SE 876, Blair v. Broadmoor 93 SE 532. We do not believe that the automobile can be placed in the same category as locomotives, gunpowder, dynamite, and similarly dangerous machines and agencies. It is true that the operation of these machines is attended with some danger not common to the use of ordinary vehicles, and we believe and have already held that those who operate these machines must be held to that degree of care which is commensurate with the dangers naturally incident to their use. Jones v. Hogue 47 Wash 663, 92 Pack 433. Next, does the regulation involve a constitutional right? The right to travel freely is a liberty interest. While personal private travel is a separate liberty interest from the driver license, the driver license nonetheless remains a property interest of which a person may not be deprived without due process of law. See Bell v. Burson 402 U.S. 535, 1971, also Goldberg v. Kelly 397 U.S. 254, 1970.
Okay, so real quick, understand that what they're saying here by reading these cases, which in the Supreme Court have already ruled, or the federal district court have already ruled, which then becomes positive law. So these aren't just court cases. When they decide these things, that becomes the law. That is law. So they've already ruled on this. And it's been challenged and challenged and challenged. That's why we keep winning, 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 because we're right. We're not wrong. A number of officers don't know that because, and I don't blame all of them, except the dicks out there. Most of them are actually good, believe it or not. But once again, I digress. How many bad officers do you have on the force if you fail to report one of your fellow officers to the internal affairs? Yes, I know about these things. And I know you can do it anonymously. But I'm not mad at most of them because here's the thing, they're not taught this. Almost nobody teaches this. They teach you just what's inside the sandbox. And why do you think that they hire so many like ex-military people, former military people? Because they don't answer to anybody. Once you tell a military person something from a commanding officer, they go into military mode, which is what the military did to their mind. Then they think they're right because they read a couple of words and their boss told them to do it this way, but they don't know all of the law that supersedes what they're doing. They don't understand certain jurisdictional things. Once they have something locked in their mind, that's it. So we're not here to argue and fight on the side of the roads because that's what they want. We're not going to give them anything that they want. They want you to argue and fight and do something crazy on the road so they can seem heroic and then blast you on TV as the enemy and a sovereign C word. No, 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 no. If they're going to overstep, I mean, you do have the right to protect yourself within reason. But if they're going to tow your car or ticket you, okay, just sue them in the municipality later. Go after them financially in their public or private capacity. I make these videos not just for the average national, but also for law enforcement. My neighbor, former law enforcement. My nephew's wife, former law enforcement. Some other people I know out there, I'm not going to mention their names, also former law enforcement. I know some that are still on active duty. They know exactly what I do. Matter of fact, they usually just giggle. Like, okay. There's commanding chiefs, commanding officers, all know exactly what I'm talking about. And some of them don't like it, but they know it's real. Some of them have had candid conversations with some of my clients. I was like, hey, it's one guy's brother. He was like, yeah, my brother's a police officer. Said all that stuff is crap. There's nothing to the passport and whatever else. I said, okay, get it done and go and show him. So he did. I was blown away. He ran it and seen what information he could see on there. He said, I've never seen anything like this. Yeah, because you're not supposed to know. Not that you can't know. They just don't want you to know. To my officers out there, go ahead and ask your commanding officer politely. See what answer you get. You may be pulled into the office and the door shut behind you privately. If he's a good commanding officer or chief of police, or else ask to talk to the legal department. Or look at them for yourself. Oh, by the way, and ask them why are the names always in capitalized letters? Go ahead and try to write a ticket with someone's name in all lowercase letters and see what happens to you. See what happens to the ticket. See what happens when legal fills up and rips you a new one. Don't take my word for it. I've already had other officers. I had some people becoming an officer do some things, say some things. I told them not to do it. Yeah, me, the wolf. I said, no, don't do it. So if you want that job, don't do it. When you're there, you are a U.S. citizen. People always want to test. It's like, come on, wolf, that can't be a thing. And then you get your hand slapped. You guys are grown. I take no responsibility for anything that you use. None of my files, forms, videos, et cetera, et cetera. There's a reason why I know these things. I've looked into all those things. I was going to become all of these things. Started learning, got friends and family in these things. Let's get back to it, shall we?
1970. If the right of passing through a state by a citizen of the United States is one guaranteed by the Constitution, it must be sacred from state taxation. Further, it may be said that a tax of $1 for passing through the state cannot sensibly affect any function of government or deprive a citizen of any valuable right. But if a state can tax a passenger of $1, it can tax him $1,000. Crandall v. Nevada 6 Wall 35. Indeed, the very purpose of constraining the state to comply with the limitation.
Now, here's the thing. So I wondered about that and how many people could sue then, say like Illinois. I mean, they've got those taxes everywhere, right? You want to know how they get around that? Because to me, that would be a lawsuit, right? If you take the states created, paid for by them, but really by the people, but private highway toll system, the straight shot through, you can't do anything because that's a privately created by the state road for their members. When you pass through, you're saying I'm a member or I'm waiving my right to the free, non-direct, all the way around, back and over here, swirly over here, like some of y'all apologizing ain't a straight path. But just like their road, if it's not a straight path, as long as they have a road around, even if the roads are crummy and dangerous, is your remedy. These guys are clever, man. They literally have think tanks that sit around to think these things up. While they watch my videos, because I'm doing their job kind of for them. Well, I'm not actively, though I will say I was approached, and I will leave them nameless, many times to do these things against you guys for them. And I missed out on a lot of money. So if money was my only goal, it would have been wise for me to take the jobs. So it does annoy me when some people message me or leave stupid comments, which is why I normally have the comments off. I don't like your comments. I just want to listen to the video. I don't like it when you're asking for donations. Well, then go to another channel and or find this information. You take time and time and energy away from your family, and a whole lot of money I could have made, and I chose not to do it for the greater good of people in a professional manner and with a little humor. But okay, I get it.
Limitations of the Constitution was to protect the rights of the people from intrusion, particularly by the forces of government. So, we can see that any attempt by the legislature to convert the act of using the public highways as a matter of right into a granted privilege crime is void upon its face. The state cannot diminish rights of the people. Hurtado v. California 110 U.S. 516, see also Miller, supra, Scherer, supra. We know that taxes are of two varieties, direct and indirect. A direct tax is notoriously either a strict percentage or a flat rate, and applied to a specific, tangible, thing or group. An indirect tax is applicable to a thing or class which tends to be passive in nature. The excise tax paid to renew the tabs on a vehicle business is a quasi-direct tax on the vehicle itself but indirect in nature, as to the business it purports to represent. One invariable limitation upon the power of taxation is that it must always be exercised for the benefit of the public. Whether or not a particular purpose of taxation is a public purpose, is a question which must be determined, in the first instance, by the legislature. But its determination is not conclusive. And if the courts can see that the purpose of the tax is plainly and indubitably a private purpose, they will not allow its collection. Black, Constable Law, page 336. Among the purposes unquestionably public in every proper sense of the term the author last quoted, page 340, mentions the construction, repair, and improvement of public roads including highways, turnpikes, and paved streets in cities. See also Cooley on Taxation 3D ed. EP.
At this point, shouldn't these cities, municipalities have a surplus? I mean, they're supposed to be the most business professional. Don't they have people that make sure that they stay in budget? Shouldn't they have a surplus? Shouldn't we have like a every 5 years or 4 years we pay no taxes, right? Wouldn't that make sense? Or reduce taxes, or get some kind of major tax credit for the whole year? I mean, something. Yeah, we could have that if you guys would stand up. I'm showing you guys the fire. You have to pick up the torch. I'm lighting the spot where the fire is. You guys have to light the way. Or not. Keep going over by P. Diddy's house and grabbing your ankles. Take that, take that, take that. Can't stop, won't stop. That's up to you. The dedication of my work was to get me here to show you guys this in front of a group of people. Now, from here, it's up to you guys. Let's go.
P.182. Lowell vs. City of Boston, 11 Massachusetts 454, 462, was case involving a question of taxation, Mr. Justice Wells says. The power of the government, thus constituted to affect the individual in his private rights of property, whether by exacting contributions to the general means, or by sequestration of specific property, is confined, by obvious implication as well as by express terms, to purposes and objects alone which the government was established to promote, to wit, public uses and the public service. So far as it concerns the question what constitutes public use or service that will justify the exercise of these sovereign powers over private rights of property, which is the main question now to be solved, this identity renders it unnecessary to distinguish between the two forms of exercise, as the same tests must apply to and control in each. Emphasis mine. The law applied to motor vehicles. Babbitt Section 66, at 131. The manner in which all forms of taxes other than a direct tax affect the present consideration is as a tax on the privilege of carrying on the business, that is to say, of using and operating the vehicle. The law applied to motor vehicles. Babbitt Section 90, at 145 citing, Cooley on Taxation, 3D ed. In these next three citations from Babbitt, we see that the state
On a specific route, it is for the state to place a payment.
Of the New York bar citing, Texas and PAC. R. Company v. Interstate Commerce Commission, 162 U.S., 197, 218. Vehicle/motor vehicle to subcontract drivers or are driven by employees. There are a variety of factors which determine that relationship. 1. The operator owns the vehicle and hires employee drivers to execute the business transaction with the public. 2. The operator owns the vehicle but leases it to a subcontract driver, assigning an element of risk and a de facto benefit to the driver, whereby the subcontract driver would have to insure the vehicle to protect the operator's interest. The two examples above should not be considered exhaustive or limiting to establish the relationship. With and for the purpose of this discussion, below is established plausibility for both. Starting with the Constitution of the State of Washington. The state constitution is tantamount to the Magna Carta, which is, simply stated, a charter. Constable Art. I Declaration of Rights Section 16 Eminent Domain. No private property shall be taken or damaged for public or private use without just compensation having been first made. Whenever an attempt is made to take private property for a use alleged to be public, the question whether the contemplated use be really public shall be a judicial question, and determined as such, without regard to any legislative assertion that the use is public. Constable Art. 12 corporations other than municipal Section 1 corporations have formed. All corporations doing business in this state may, as to such business, be regulated, limited or restrained by law. Section 10 Eminent Domain affecting. The exercise of the right of eminent domain shall never be so abridged or construed as to prevent the legislature from taking the property and franchises of incorporated companies, and subjecting them to public use the same as the property of individuals. Section 13 Common Carriers, Regulation of. All railroad, canal, and other transportation companies are declared to be common carriers and subject to legislative control. Section 18 Rates for transportation. The legislature may pass laws establishing reasonable rates of charges for the transportation of passengers and freight, and to correct abuses and prevent discrimination and extortion in the rates of freight and passenger tariffs on the different railroads and other common carriers in the state, and shall enforce such laws by adequate penalties. A Railroad and Transportation Commission may be established and its powers and duties fully defined by law. A service is said to be performed when one takes to perform a task or duty for which there is no instruction, guidance, or assistance from the party receiving the benefit of said service. However, a service may still be performed if the parties agree that the beneficial party assumes some portion of the risk for consideration. In the case of the taxi and tow truck company, they provide a service and therefore provide the driver. That driver may be either a subcontractor or an employee depending on their agreement. In the case of the moving company, they hold out their business to the public, but they are considered a private contract carrier because they provide a private service and do not hold open their business for the general public at large as would a bus company or ferry service. Moreover, the moving company may provide a driver, his employee, or it may sublet the vehicle and allow the sublet to drive the vehicle or their hired driver. The moving company, like the car rental service below, would agree to sublet contract to a person in consideration of a reduced fee for the interest. If a person rents a vehicle from a car rental service company, he will be required to sign a contract agreement to provide a driver, or at a minimum have a driver license, which is the same thing. Likewise, signing a contract to provide the lessor with his insurance company information or purchase insurance from their insurance provider. If a person provides insurance and a driver, he is a sublet contractor. If, however, a person purchases the service fully at the lessor's proviso, then he is merely contracting a service from a private carrier. While the question of contract as to a driver license is settled law, it remains a clever focus of clandestine artifice. The vehicle license actually created a contract, because it is the business. The term contract means to come together and make as agreement, assimilate. To say that one agrees to be bound by the Motor Vehicle Code can be established merely by asking if there are license plates on the vehicle. Here's why. The individual consented to convey the property, the automobile, to state legislative control. Start with the Constitution of the State of Washington, Declaration of Rights. Constable Art. I Section 1 Political Power. All political power is inherent in the people, and governments derive their just powers from the consent of the governed. On the idea of consent, the legal maxim of law is stated thus: Non potest rex subditum renitentem one rare impositionibus. Meaning the king cannot load a subject with impositions against his consent. When an individual voluntarily registers an automobile with the state,
There it is.
be so abridged or construed as to prevent the legislature from taking the property and franchises of incorporated companies and subjecting them to public use the same as the property of individuals. For the same reason that doctors, dentists, and daycares provide the street address of the buildings where they have their business practice, is why the vehicle is registered. The license plates perpetrate an address for the place of business. If the doctor, dentist, or daycare attempted to practice without a license, the state would have authority to injunct the premises to prevent further unlicensed practice. While the vehicle, business, has the good fortune of being mobile, the state would likely seize the vehicle to prevent unlicensed practice, unless, and with prejudicial discretion on the part of the policy enforcement officer, a licensed driver were to take control of the vehicle. It is not such a reach to suggest that a person, however subtle, may be transporting state persons and state property for the state, in the interest of community proliferation, exercising and thusly stimulating the economy, for which the state has mutually benefited from a person's travels, having at a minimum collected sales taxes from a myriad purchases from other merchants, now have the expectant obligation to report to the Internal Revenue Service the cash value of those travels as income to the state. Possession of a driver license and a vehicle business license is regulated by a legislative grant of authority under the Constitution. The Charter gives the legislature authority to regulate all other transportation companies. Vehicles and motor vehicles are, by license, transporters of persons and property, which makes them a common carrier. Section 13 Common Carriers, Regulation of all other transportation companies are declared to be common carriers. The Congress of the United States and the state legislature proliferate the dichotomy of interstate and intrastate commerce by qualifying and distinguishing purpose and capacity. For instance, there are three major divisions of carrier: common, contract, and private. Common carriers deal almost entirely with quantum mass public movement, trains of any size or rail, buses, trams, and ferries. Contract carriers are transfuse, meaning they can either transport, by contract, a large shipment for a common carrier or a smaller shipment for a private carrier, i.e. moving companies and postal shipping companies. Contract carriers operate for the public benefit by way of private contract. Both common and contract carriers are predominantly classified by axle weight, tonnage, or prejudice of easement, as of railways or waterborne vessels. The private, for hire, carrier is as diverse as it is transfuse. The private carrier is of two calibers: those carrying greater than 16 passengers and/or 26,001 lbs, versus those carrying less than those limits. Here the classification being lesser axle weight and/or lesser passenger capacity, the automobile bottom feeds on the smaller contracts of the larger counterpart, but still is able to bill itself as a publicly offered common carrier. These types of vehicles are pickup trucks and small panel trucks, and anything from a subcompact two-door sedan to a stretch limousine. Tow trucks, taxis, ambulances, postal trucks, ice cream trucks, milk trucks, police cars, dial-a-ride taxis, and plumber trucks. All of these vehicles use the highways as a place of business. It seems obtusely obvious to say that these vehicle businesses could not exist without the highways, because they transport persons and/or property upon a public road and they get paid to do it. When taking into consideration the definition of commerce, from calm together plus Merck's merchandise, look around while commuting on the roads and visualize the highway as a sidewalk marketplace not unlike the Pike Place Market, with all the vehicle businesses lined up booth to booth to booth, conducting a business hawking their wares. More succinctly, the roadways are governed because of the vascular connectivity. That is to say that commerce itself, the act of exchange and trade, is done privately, on private property, in private buildings, on private phones. It is transportation, after the fact, when the goods or commodities need to be exchanged, that requires delivery to the purchaser. That delivery, requiring space on the roadways, is incidental to the normal use. Driving. Now, as shown infra, the legislature has clearly outlined the parameters of driving as that which is commercial by common carrier, private carrier, and private for hire. What is of importance is the type of use. Personal use of the roads does not occasion the need for a license. The legislative body acknowledged a right to beg that does not rise to the level of aggressive solicitation, or it would have prescribed begging altogether. By expressly prescribing one type of solicitation, the ordinance implicitly allows other types not otherwise prescribed. See State v. Delgado 148 WN 2D 723, 729, 63 p.3d 792, 2003, under expressio ianius est exclusio alterius, a canon of statutory construction. To express one thing in a statute implies the exclusion of the other. Quoting in Re Detective of Williams, 147 WN 2D 476, 491, 55 p.3d 597. City of Spokane vs. Mar 129 WN App 890. See also Brown Edwards v. Powell 144 WN App 109. It is obvious that those who operate motor vehicles for the transportation of persons or property for hire enjoy a different and more extensive use of the public highways. Such extraordinary use constitutes a natural distinction and a full justification for their separate classification and for relieving from the burden of the license tax those who merely employ the public highways for the transportation of their own property or employees. Bacon Service Corporation vs. Huss, 129 calories, 21, 248 p. 235, State vs. Carell, 180 so. 3 at 8. The term travel or traveler, while typically neuter, refers to one who uses an automobile or a vehicle to move from one place to another, and includes all those who use the highways as a matter of right. The term driver is a contradistinction to traveler, as defined. Therefore, one who uses the road in the ordinary course of life and business, for the purpose of travel, is a traveler. The term for hire is a rhetorical term, and is defined as a person who holds himself out for payment of a fee or fare in exchange for transfer of some other's property or passenger. Considering the heuristic poignancy of this writing, let's review the charge of DWI. Of the many courtroom arguments that litigants get into, then relying on judicial discretion for resolve, the argument of "I'm not a driver" or "I wasn't driving" may come up, so then the judge would have to consider the definition of driver. Remember though, the judge will always, saving grievous error, favor the state. So, according to the ruling below, in order to actually convict for driving under the influence, it must be established that a person was actually driving. If one has a license, the presumption is in fact that one was driving.
There it is.
When analyzing the concept of misconduct, the trier of fact must consider the legal definition in context with the factual circumstances surrounding the conduct at issue. Garman v. State Employment Security Department 102 Nevada 563, 729 p2d 1335, 1986, Jones v. Rossner 102 Nevada 215, 719 p2d 805. In and of all the research founded, the great many courts across this country, including Washington courts, do not visit the discussion of driving v. traveling, very often exceeding decades. At that though they usually will divert attention to some other question of fact or law. As much as driving is an element of a statute crime, in arguing civil and criminal litigation, there is almost always more than one issue raised on appeal, and the courts will not address the driving v. traveling issue when given another option. Due process requires that the prosecution prove each element of a crime. In Re Winship, 397 U.S. 358, 90 S, CT 1068, 25 L, ed. 2D 368, 1970. Jury instructions must define every element of the offense charged. State v. Johnson 100 WN 2D 623. Emphasis mine. The omission of an element of the crime produces a fatal error by relieving the state of its burden of proving every essential element beyond a reasonable doubt. Additionally, failure to instruct the jury on every element of the crime was reversible error because such an error relieves the state of its burden of proving every element beyond a reasonable doubt. State v. Eastman, 129 WN2 D497, 919 P.2 D577, 1996, State v. Daniels. 87 WN App, 149, State v. Bird, 125 WN2 D707, 887 P.2 D396, 1995. The construction of the Constitution of the United States by the Supreme Court is binding on a jury as well as the court. U.S. v. Shive 20 Federal Dig. 439, Federal Cass. Number 16278, Bald. 510, 1832. As is indicated in definitions at RCW 46.20.040, drive and operate shall mean the same thing, to be in actual physical control of a motor vehicle, except that it is shown conclusively herein that driving is not operating. The statutes of the state of Kansas read near word for word identical to Washington statutes, so it was stated in State of Kansas v. Kendall 274 Kansas 1003, 58 P.3 D660, that the action of physical control of a motor vehicle is therefore transportation, and therefore the basis of commercial activity. Kansas Statutes of 1999. We know that transportation of persons or property is a commercial activity. While the term property is restricted to tangible physical items, to which possession is claimed by title, contract, or receipt, bill of sale, bill of lading. The term person is a more broad term, and in the transportation of persons the term may be expressed as a rider, quest, or passenger. No matter which phrase is used, or the caliber of vehicle, be it public or private, to transport a person means there is the axiomatic payment for such carriage. A rider does not always pay a fare, in the case of a driver trainee, or husband and wife long haulers, or taking a cameraman along to film an activity, whereby one does the driving and the other's presence is merely migratory. Contrastly, a rider may pay a fare as a second or third party in a taxi where the initial fare is borne at a stipulated rate or mileage, and the second and or third passengers pay a surcharge, as it were. For carriage, having created additional transcendental wear and tear on the vehicle. The term guest is similar to that of rider, having much of the same attributes, but moreover is someone who was invited, and as such is a mere invitee. Guests are incidental to businesses that hold their doors open to the public, but the presence of the guest could be non-commercial. A fee charged for service is borne to the user, and the guest is welcome at the invitation of the user when the user has paid a bulk rate, as it were, for the service. The term guest is appropriate when the demand for fare is discretionary and contingent on the intended use. For instance, a hotel charges a rate for guests who would use a room for staying the night. A hotel would not, however, charge a fee to a guest who was attending a conference in a hall. As it relates to the highways, a person may hire the services of a limousine company, the operator, and the limousine company would provide a driver, and for that fee, the limousine would take any number of persons on an excursion. Only one person paid the fare and all other riders are guests. The term passenger is quantitatively similar to each of the definitions above for each of the stated reasons. The term passenger is derived from passage. A passenger in a vehicle is one having right of passage upon payment of fare. It is argumentative to say that the actual passenger paid the fare, more certainly because a passenger could have received the right of passage from a third person who paid the fare but is not the passenger. The term passenger ordinarily imports some contractual relation between the parties. Long v. Archer et al. 221 IND 186, 46 in E2 D 818, citing Gale v. Wilbur 163 Virginia 211, 175 SE 739, Bushhouse v. Brom 297 Michigan 616, 298 NW 303. There is involved here, not a common, but rather a gratuitous, carrier. The legal definition of passenger is twofold. Many definitions may be found for this relationship between the one conveyed and the conveyor. facts always control in an individual case. When speaking generally upon the subject of common carriers, this court said, in Weber v. Chicago, R. and P.R. Company 175 Iowa 358, 151 NW 852. It is not easy to state a general rule, nor to give a definition of the word passenger which would embrace all the essential elements. As said in 2 Hutchinson on Carriers, 3rd ed., Sector 997, the one usually accepted by the courts, when a definition has been attempted, is that a passenger is one who travels in some public conveyance by virtue of a contract, express or implied, with the carrier, as the payment of fare, or that which is accepted as equivalent therefore. This definition, however, like all others, is hardly comprehensive enough, for, as a general rule, every person not an employee, being carried with the express or implied consent of the carrier upon a public conveyance usually employed in the carriage of passengers, is presumed to be lawfully upon it as a passenger, first, an undertaking on the part of the person to travel in the conveyance provided by the carrier, and second, an acceptance by the carrier of the person as a passenger. Whether either or both of these elements exist is ordinarily a question for the jury. Puckett v. Palethorpe 207 Iowa 613, 223 NW 254. Persons who drive are drivers. So, what is it to drive or be a driver, or do the driving? Firstly, we recall the definition of driver, as being one who is employed, in Bouvier's and Black's Law Dictionaries. To expound on that definition, the following rulings make clear that drivers and driving is strictly a commercial venture and does not apply to all who use the public roadways. For instance, in the Transportation Law Journal, 27 Trans LJ 113, 2000, there is lengthy discussion about for-hire conduct of taxi cab driver/owners. For purposes of this record, the following excerpts were found to be expositive of the nature of a driver license. The condition of vehicles used as taxi cabs, the chauffeurs operating taxi cabs, the companies providing taxi cab service. The journal article is replete with use of the terms taxi cab chauffeurs, taxi cab license owners, owner/driver, taxi cab drivers, taxi cab license holder. It should be stated that while a license to operate a taxicab business is distinct from the license to physically drive the vehicle, there is the axiomatic relationship of owner/driver. The journal article also references, sub silencio, the Florida statute which calls for what is termed a for-hire license. The distinctions between owner and driver are discussed further at Wallace v. Woods Infra. The above journal review is an overtly expositive narrative of how cab drivers may or may not own their own vehicles but would stand to make more money in the exercise of their trade if they did in fact own their vehicles, and were therefore owner/operator, instead of merely employees, then paying the business operator for the use of the vehicle. The journal also discusses the intrinsic relationship of the government then having authority to regulate the business of both the operator and the driver. The most revealing statement of the journal narrative, 27 Trans LJ 113, is stated thus. Anyone who owned an automobile could provide taxicab service. It is the foregoing quote from the journal that raises the most litigious concern, the presumption. This presumption is the basis for the police to stop the unsuspecting motorist and issue a traffic infraction and more significantly reproach the general traveling public with the entirety of Title 46 RCW here in Washington. It is important to recognize when there is discussion of private carriers we see the term vehicle, when there is discussion of common carriers and contract carriers we see the phrase motor vehicle. This is congruent with the federal definitions of motor vehicles and the context of common carriers. Highlighting the discussion in 27 Trans LJ 113 above, we look to the following cases: Howard's Yellow Cabs Incorporated v. United States of America 987 F. Sup. 469, 97-2 U.S. Tax Cass, CCH, P50, 694, 1997, and J&J Cab Service Incorporated v. United States of America 98-1 U.S. Tax Cass, CCH, P50, 360. Both cases involve cab company operators. In Howard's, the following language is used by the court, see similarly, dictum at J&J Cab Service. As found by the magistrate judge, the facts are as follows, that the drivers collected money from the cash-paying riders, that, plaintiff, gave the drivers credit for any contract riders whom they transported, that the drivers settled up with the dispatcher by giving him 50% of the money collected from the cash-paying riders when such amounts exceeded the amounts due the drivers for the contract riders which they had transported. The Howard Court, citing Manchester Music Company v. U.S. 733 F. Sup. 473, stated at footnotes. A payment occurs with the transfer of possession, dominion, or control over money or its equivalent from a person who up to that point had been exercising such prerogatives over the same to another who is due the funds. The previous citations describe the use of a vehicle, driving the public for hire. Below is the description of the use of a private vehicle not for hire yet with the employ of a driver nonetheless. In the case of Ford Motor Company v. Stella D. Imadin et al., 987 F. Sup. 469, there is the distinctive act of driving a vehicle at the direction of an employer because the employer had control of the vehicle. The driver was an employee of Ford Motor Company and thusly, subsequently, remunerated by a private party to drive vehicles for the purpose of attesting as to the vehicle marketability. In this case, the dealership operated the vehicle although someone else drove it. An operator is defined as one who has actual physical control over a vehicle or a motor vehicle. Operating a vehicle is also defined as one who facilitates or augments the movements of the vehicle. In the two preceding cases, the cab company operated the vehicles because they had the authority and/or the ability to determine when and where the drivers would pick up and deliver or transport passengers to and from. A license to carry on a business or trade is an official permit to carry on the same or perform other acts forbidden by law except to persons obtaining such permit. Hofling v. City of San Antonio, 8510. 228, 20 SW 85, 16L, RA, 608. In some cases it is held that where a license is for the protection of the public and to prevent improper persons from engaging in a particular business, and the license is for revenue merely, a contract made by an unlicensed person in violation of an act is void. Beaudre v. Carter, 64 Mississippi 221, 1 South. 162, 4C, B, N, S, 405, Johnson v. Hewlings, 103 Pascals, 501, 49 AM. Republic 131, Hustis v. Pickens, 27 Il App, 270. When the power is exercised by municipal corporations, a license is the requirement, by the municipality, of the payment of a certain sum by a person for the privilege of pursuing his profession or calling, whether harmful or innocent, for the general purpose of producing a reliable source of revenue. Tide. Lim Paul Pow. 271. Require. Expense of. A reasonable. Plain case of. In the regulation of occupations harmful to the public, it is constitutional to those who apply for a license to pay a reasonable sum to defray the issuing the license and maintaining the proper supervision. What is? Some must be determined by the facts of each case, but where it is a police regulation, the courts are not compelled to be too exact in determining the expense of regulation and supervision, so long as the sum demanded is not altogether unreasonable. Tide. Lim Paul Pow. 274. City of Boston v. Schaefer, 9 Pick. Massachusetts, 415, Welch v. Hawkes. 39 Con 140, 12 AM. Republic. 383. Think of the distinction between driver and operator more like open ocean racing, or hydroplane racing, stock car racing, or Baja Sand Rail racing. There is a very distinctly separate function between driving and operating, not accepting that the operator could be the driver. It may be easier to understand operator in the context of navigator. When racing cigarette boats and sandrails, there is a driver and a navigator. One person drives, by depressing the accelerator and the brake and turning the steering wheel, and the other person manipulates the vehicle by coordinating and directing its destination. Or, in the case of the hydroplane and stock car, there obviously is a driver, but the pit crew is the operator because the pit mechanic controls the changing of tires, foils and windshields and has the ultimate responsibility to determine the serviceability of the vehicle and, therefore, determine if it is in an operable condition. However, a driver can be the operator if the vehicle is maintained, navigated, and driven by one individual, as in the case of a sole proprietor business. Another example of driver/operator is NASA, National Aeronautics and Space Agency. Yes, flying constitutes driving by federal definition of law. The flight crew drives the shuttle to the moon, while the control center operates the shuttle by monitoring critical functions and navigation. The Howard's Court above also established the fact that the drivers had personal use of the cabs during the day. An empowering correlation to Howard's above are the cases of City of Chicago v. Gall 195 Ill App. 41 and State v. Sheffel 82 WN2 D 872. In the Chicago case, it was recognized that simply because there existed a license to operate a vehicle does not mean that any person is fully engaged 24 hours a day in the operation of that business. Equally, it was said in the Sheffel case that use of an automobile, during certain periods, as a vehicle does not preclude its use as an automobile when not being formally used as a vehicle. To further amplify the distinctive nature that is driving, we find at Transportation Law Journal, 35 Trans LJ1, which is excerpt for brevity, not to lessen the context, more certainly for clarity, as follows. In the motor carrier industry, the employment classification determination is frequently critical because of the high incidence of use of owner operators. Footnote: the term owner-operator reflects individuals who lease motor carrier equipment to a motor carrier with driver services. Normally the lessor performs the driver service. Other carriers operate a fleet utilizing driver employees as well as owner-operators. Driver employees were utilized and were paid hourly wages. The drivers take upon themselves to complete a freight movement. Most drivers, whether employee or an owner-operator, are paid on a per-mile basis. It is obvious that a driver and owner-operator could increase his pay by driving more miles and handling more loads, and overtime as desert would increase the temptation to do so despite the wear and tear on the equipment and, more important, to the health and safe performance of the driver. Significantly, the federal legislators recognized this and felt that two different units of the government and approaches to wage and hour issues should not interfere with each other. Safety of the public and the operators won out, and thus the Secretary of Transportation, who was presumably more knowledgeable of trucking operations, was given the power to dictate the hours of service which drivers could drive based, in part, of the normal operations of carriers. Historically, the view of the courts is that the history of a statute is important when attempting to understand, evaluate, and implement a current version. As shown below, the historical purpose of the statute, as opined by the court, is conducive of the legislative statement in 1965, see section on statutes. This reading is prejudiced to the phrase traditional freedoms to which every motorist is entitled, to exemplify that not everyone placing and using their personal automobile on the highways needs a driver license. Further, by extension and implication, even a numbered business license plate on their personal automobile. The primary rule of construction of statutes is to ascertain the lawmaker's intent, from the words used if possible, and to put upon the language of the legislature, honestly and faithfully, its plain and rational meaning, and to promote its object. And the manifest purpose of the statute, considered historically, is properly given consideration. 2 Lewis Sutherland on Stat Constant, 2 ed., Sector 363. Endlich on Interpretation of Statutes, Sector 329, and Maxwell on Statutes, 5 ed. 425. Emphasis mine. Wallace v. Woods Infra, citing Cummins v. Kansas City Public Service Company, 334 MO 672, 66S, W, 2D, 920. That is, where a statute has been construed by the highest court of the state, the court's construction is deemed to be what the statute has meant since its enactment. In other words, there is no question of retroactivity. Emphasis mine. State vs. Moan 129 WN 2D 535, 919 P.2D 69, 1996. Notice here that the judiciary has stated that inquiry must be to the historical intent of the statute to properly determine its present intent. The court further explained jurisprudence based on the whole act rule, stated thus. Said. With a view of determining the meaning of the word driver, all provisions of section must be considered. Wallace v. Woods Infra, citing Bowers v. Missouri Mutual Association, 62 SW 2D 1063. Statutory references to driving have always been about compensation. As seen below, the phrases drive, driver, and driving are only for those who receive compensation for their skill. Underlined for emphasis are the key words used by the judiciary in their own description of driving. Doing. Certainly a driver is only one who drives. A stagecoach driver may have had unusual authority on his trips, see Drolshagen v. Union Depot Railroad Company, 186 MO 258, 85 SW 344, but we know of no good reason why the word driver would not be commonly and reasonably interpreted to be the person actually the driving, whether he was one he employed be the owner to drive or whether he was the owner driving. If such terms expressed the purpose of subsequent amendments, there was no reason to change them merely because the statute was being made applicable to situations beyond its original scope. We cannot now judicially know the situation as to how often owners drove their own stage coaches or how many were driven by hire drivers. However, we do know, and we are sure that the legislature knew, when and after they later inserted the words motor car and automobile in this statute, that many owners of motor vehicles used for public transportation off both freight and passengers did drive them in such service. It seems reasonable to believe that, in all the amendments broadening the scope of the Act, there was some purpose in using and continuing to use different terms with respect to railroads and other instrumentalities of public transportation. Emphasis mine. Wallace v. Woods 340 MO 452, 102 SW2D 91, 1937. As one may well establish by the length of this reading that driving is and must be of a commercial nature. The term commercial means to engage in commerce. To produce, deliver, and receive payment is commercial, as being in commerce, everything from trucking coast to coast, to the variety of the local fast food joint, where they produce a cheeseburger, deliver it over the counter, whereupon credit is transferred to the store. The plumber may be the best example, here, of operating and driving in commerce and private carrier, under 16001.lbs. The plumber epitomizes the very substance of these definitions. Title 81 RCW is the best definition of plumber. RCW 81.80.010, 6. Of private carrier is a person who transports by his or her own motor vehicle, with or without compensation, property which is owned or is being bought or sold by the person, or property where the person is the seller, purchaser, lessee, or bailee and the transportation is incidental to and in furtherance of some other primary business conducted by the person in good faith. Let's rewrite the statute definition for purpose of this writing. A plumber is a person who transports by his company truck, van, with or without compensation, your new shower stall which is owned or is being bought or sold by the consumer, client, or property where the plumber is the seller, purchaser, lessee, or Bailey, and the transportation is incidental, after being picked up at the warehouse, to and in furtherance of working on your bathroom conducted by the person in good faith, that you will pay him for his services. Now let's excerpt that definition. A plumber is a person who transports by his company truck, van, your new shower stall which is bought by the consumer, client, or the plumber is the Bailey of your new shower stall, to and in furtherance of working on your bathroom. Remember, no driver license is needed to operate a business. Conversely, no operator license is required to drive. When the state of Washington defined driver and operator to be the same thing, it in fact was intended to reify these two separate functions in order to bridge or bootstrap common law traveling. Because then, most common people that have the driver/operator license fit quite neatly into this perverse extrapolation. Licensing.
All right. Did you hear that? It's beginning to look a lot like freedom. Everywhere I go. Wouldn't you like to be operating like you and me? Get your license and go. What's going on, people? That's the end of this particular section. I think after this one, we have licensing, and just trying to see what other sections we have left. Yeah, licensing, the anatomy of a traffic infraction, and then looks like a little bit of tort liability I'm going to talk about, and that will be the conclusion. After this part is all done, I will probably make one more complete right to travel video, and that will be it, unless something new or interesting pops up, because we have covered it. As I've told you guys before, I'm only going to keep bringing you new information, and when that has been exhausted in those particular areas, I mean, we've covered the major chunks. There's some subtleties and some little nuances, and that we could cover, I guess. But as we've already been winning, um, I don't think that we really need to. But some of those smaller things, maybe I will put into the seminars, and you guys can learn some of the minutia. All right. We don't need to know all of the minutia because we've already been, like I said, winning with what we have. All right. So there's no real reason to to go into that. But once again, for those people who want to nerd out like me and learn those things, I will definitely teach you. It's going to be a very interesting course. By the time you guys are done with the seminars, the key ones, the ones that I charge for, there's going to be some free ones, but the ones that I will charge for, there's no reasoning behind you guys not being able to do exactly what I do for yourselves and other people. Hell, a majority of the videos that I've already given you guys, people have already launched their entire careers and campaigns, a majority of which have been for good and at reasonable prices. Um, some people, on the other hand, not so much, either on their own or using bits and pieces of my information. I do find it amazing how, some people out there don't like me, but try to be just like me. I don't get that part. And then use some of my information on their videos. Oh yeah, I watch. I watch. Matter of fact, I'll give you guys, some of you guys is solid. I'm in a lot of your groups out there. I just don't happen to use the Badwolf name or moniker out there. I like to stay private, if you know what I mean. Anyway, I digress. Biggest thing here, guys, is that you have learned a lot of information. This has been like 4, almost 5 hours worth of recording. Um, at least for me, it hasn't been as hard using the assistance of the AI, which makes it a lot easier. But still going through vetting information and correcting some things and updating some things. It is what it is. So this particular document, once again, was not written by AI. Matter of fact, here's one of the things before I go. What I'm going to do is I'm going to run this information through the AI so that it can start to learn the private. All right. Because it doesn't know. It can't possibly read every bit of process information. It's only pulling from key sources. So here's what I'm going to tell you guys to do. Two things. If you're watching these videos, I want you guys to do two things. I want you to get either my or somebody else's or free, whatever, right to drive documents, things stating your constitutional rights. And educationally speaking, I would say anonymously send them to the chief of police, your mayor, your governor, your alderman. Let them know about the right to travel. Now, don't go out performing any paper terrorism or anything like that. I'm just saying you have a right to inform various municipalities and courts. You can include sending them to your courts to let them know what's going on. Matter of fact, you're actually doing them a service because you're giving them a courtesy to know something that they didn't know. Now, if they don't want them, they'll delete them like they do with so many other things that they delete that we may send them at times, certain places, federal offenses, stuff like that. But by doing this, you're giving them the ability to know that they need to start training their people properly in law before the lawsuits start occurring. This is what we are tasked with doing, depending on how you want to look at it from your fellow man or your biblical perspective or legally. You're giving somebody a legal notification. Now, if you want them to know who you are, then by all means, you can definitely put your name on there. They're not going to come and bother you for the most part. They're just going to go, well, whatever. But at some point in time, and you know what? I would also address it to some of those places, but address it to the legal department in those places. Address it to the commanding officer. Send it to the people in power so that they know. They may disregard one or two, but if they start getting 20 or 30 or 100 a month, they're going to start to sit down and go, okay, we need to look at this. We have been very accommodating as American people. Never do anything unless you're forced to become a belligerent or combatant, which we are more than capable of doing. But we're going to do this the proper way as business. We have been silent, and now we're making our voice heard. And if we have to walk silently with a whisper on our lips and a big stick, then so shall we. As Americans, we are not afraid to use it. But for now, we're just going to have it for our own safety. So I would definitely tell you guys to send these documents out to those places. For yourselves, I would definitely read the Constitution, Declaration of Independence, and the Bill of Rights. Know where all of this comes from. Because if you don't, how can you stand on it? If you're not standing on your square, then they will most definitely test you. Are you guys ready for the last section? The last section may or may not be done today. So I'm probably going to wait. Probably do it Sunday. So Sunday will be the last one. So thank you guys. I appreciate you. Once we wrap everything up, like I said, we'll make materials and whatnot's available. Till then, take care. Enjoy your weekend. I'll talk to you later.